Okay, right up front. If it happens like it did last week, we will take it as a sign. If the hardware quits working in an hour and a half, we will quit. So if the video mysteriously quits working in an hour and a half, it's because, well, it quit and we didn't reset the hardware, because it turns out that if you bounce out of the recording session, well, to reset the hardware, it just closes off the recording session. You can't come back, you can't restart. There's nothing. It kicks everybody out, and we're done. So if the hardware fails, we're done. And if any information that we haven't covered, I will just post online. Okay? For all you online people. The in-person people will probably talk about the information, because that's what the in-person class is for, and these videos are supposed to be value add for the online person. So, okay? Let's get started. Big week. What happened?
We lost a member of the United States Supreme Court.
That's exactly right. We lost a member of the United States Supreme Court in an election year. Wow. 10 major decisions pending, cases coming up, including all kinds of fun stuff. We'll see what happens. And so it turns out that while it has been a long time since it happened, there is a precedent for the court going more than a year without a nomination. That's terrifying. That is absolutely terrifying. There is a precedent for the court going more than a year without a nomination, which means it could, in theory, fall to the next president instead of this president to make a nomination. And I took a survey earlier in the week, and they said, what's your favorite thing about teaching this class? And I said, my favorite thing about teaching this class is that it changes. The answers aren't right. That's why when I opened the class at the beginning of the semester, I told you this is a discussion. This isn't authoritative. This is, I mean, authoritative, I can read this to you authoritatively because it hasn't changed much of it, right? This is the Bill of Rights. I can read this to you and I can speak with some authority, but I can't make authoritative predictions on what cyber law is going to look like in 10 years. I can't make authoritative predictions on how people are going to react to the Supreme Court, how the Supreme Court is going to react to cyber issues. Will the next justice be young enough to understand what an IP protocol is? Good question. That's something that's very interesting to me. Is will the next justice nominated to the Supreme Court know about the internet, know about technology, be a technology user, be somebody who has any experience with cyber issues? Because that right there alone, changing context for the Supreme Court into a cyber knowledgeable, cyber relevant decision-making body, that's huge. Can you imagine the implications of a jurist body that actually understands cyber and knows what the full implications of those decisions are? Because right now, frequently they don't. And that's just a fact that frequently the lawmakers, frequently the judges, frequently the people who are in charge of making the decisions and drafting policy and creating and enforcing the rules under which we live don't actually understand the way we use, the way we recognize, and what the technology can do. Right? So, exciting times to live, which is an ancient Chinese curse. May you live in exciting times, or may you live in interesting times, is the actual curse. And it seems like we do. So, who knows? The thing I like about this class, though, is that it changes. Because last year, net neutrality was a huge undecided issue, and they made the decisions while we were in semester. It was great. They made the first net neutrality rules that went through the FCC and it was adopted after we wrote our net neutrality essays last year. It was a fantastic thing. I couldn't have hoped for anything better because we actually had to see how it sorted out and on which side the essays fell. That was great. But tonight we're going to get through the Constitution, finish it, and all we have left is the Bill of Rights. We made it through the rest of it, all those articles. And some of these amendments are pretty short, which is nice, right? They're not short on implications, but they are short in terms of text. Some of them are not so short. So let's just dig in, huh? When were these amendments made? Anybody? When were they proposed? Online guys, feel free to type it in. When were these amendments to the Constitution? And how many were there?
Well, 1789.
1789, 12 proposed. How many passed?
10.
10. Everybody knows that. It came to be called the Bill of Rights. But they described it right here. Where was it? I should have highlighted it. I brought the highlighter and I didn't highlight it. It was all sent to Articles. In addition to an amendment of the Constitution of the United States of America, proposed by Congress and ratified by the legislatures of the several states pursuant to the 5th article of the original Constitution. They recognized right there when they cited it as the original Constitution, meaning Articles 1 through how many articles in the Constitution? Huh?
Yes, 5%.
7. 7 articles. That the original 7 articles of the Constitution are the original Constitution, and they're cited even this early on because we see the Bill of Rights as part of the original Constitution, but they did not. Each and every one of these was an amendment to that original Constitution.
2 years.
It took 2 years. They lived under the original articles with no guarantees. And if you remember, there were some insurrections and stuff that happened during that time. There were some, what are they? There was lack of due process that occurred because it wasn't yet guaranteed. Right? The Bill of Rights had not been amended to guarantee due process of law.
But part of the passing of the Constitution.
That they would get around to passing the amendments, but they weren't proposed yet. Not in their entirety. Crazy, right? Talk about interesting times to live in. All we got is a Supreme Court justice in Congress that doesn't agree. All right.
Actually, what are these like? Article 1 to 10. What are these?
Those are the amendments.
Okay.
Article the first is the first proposed amendment. And it says, after the first enumeration required by the first article of the Constitution, i.e. the census, there shall be 1 representative for every 30,000 until the number shall amount to 100, after which the proportion shall be so regulated by Congress that there shall be not less than 100 representatives nor less than 1 representative for every 40,000 persons, until the number of representatives shall amount to 200, after which the proportion shall be so regulated by Congress that there shall not be less than 200 representatives, nor more than 1 representative for every 50,000 persons. It was trying to predict and regulate and scale the growth of Congress. Guess what didn't pass? That one. That one was not included. That should have been the First Amendment. How many times have you heard somebody say, freedom of speech, freedom of religion, freedom of petition, freedom of assembly, or freedom of the press? Take your pick, because they always cite the First Amendment as one of those, even though it's all of those. How many times have you heard them say, it's the First Amendment for a good reason, they meant it that way? Do you think these things are out of order? Has anybody ever heard this? Online guys, have you ever heard people talk about how the First Amendment is first because it's the most crucial principle of American whatever?
Quite often, yes.
Quite often, and completely incorrect in accordance with this document. The first one is, wait, Congress, this is how you should grow, this is how that should be managed, and this is the procedures, and make sure you manage it accordingly. And Congress said immediately, hey, guess what? Actually, it was the legislature, which is surprising. But the legislature said, you know what, that's not really worth passing. We're not sure we agree with that. Maybe we want to keep our extra representatives because, you know, if we sacrifice 10,000 people to the... No, we don't like the math. So they didn't pass it. That was the First Amendment. Regulating Congress was the First Amendment, and it didn't pass. Second Amendment. Article the second, no law varying the compensation for the services of senators and representatives shall take effect until an election of representatives shall have intervened. What does that mean?
You can't vote to raise your salary.
You can't vote. How would they have phrased it? One shall not vote one's largesse out of the public treasure. That's what it means. It also didn't pass.
Go figure.
I can't imagine why. Hey, maybe I want to give myself a raise. Maybe I want to, maybe I work hard and I deserve some more money. Or maybe I became a career politician, which I know that wasn't the, I'm not even sure which politician I'm making fun of right there, because I think that was a combination of George Bush and Bill Clinton in my voice there. But, really Southern, whatever. But what that is there is it's supposed to be an anti-corruption law. That was supposed to be, and it's the second thing. They're like, hey, we see this could be a problem because we've already lived under these articles for a couple days, and people are talking about a raise. Maybe we didn't give ourselves enough money. So let's include this. Let's make sure. And guess what? It didn't pass. Actually, it did pass. When?
Later.
If you fast forward all the way to the last amendment, it says in 1992, no law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. That passed in 1992, just in case you were wondering. Originally proposed in 1789. Class is over. This doesn't make any sense. It's not over. That's a lie. It literally took that long, and one of the reasons I bring this up right up front is because a Sam Houston student is responsible for it passing.
Really?
I wish I could remember the guy's name. He was a protege of John Holcomb, who was a professor here for a long time. He died literally in his office 2 years after I got here. He was a good friend and a great guy. Incredibly brilliant political scientist. And there's even a room named after him on campus and whatnot now. He's a great guy. But he so inspired one of his students. Hey, guess what? One of those amendments that was originally proposed, and he inspired him in the 80s, one of those amendments that was originally proposed didn't pass. And the student was so, hey, I like that amendment. And wait, nothing's ever happened. That student got involved because of his lectures and started writing the legislatures of every single state. And it got picked up and passed. Fantastic. That was one of his claims to fame. He would tell that story in every single class he taught. And I enjoyed it all 3 times I heard it. It was fantastic. All right, so let's move on to the ones that we actually know about, which is the Third Amendment. Oh wait, where's it first? Article the Third. Ah, now we're getting somewhere. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people to peacefully assemble and to petition the government for a redress of grievances. What a Charlie Foxtrot. Don't people say it's the right to freedom of speech? Some people say the freedom of expression. Some people say freedom of religion with their nose in the air. Other people say it straight to your face. Other people say it however they interpret that, because that is such a spinning circle of whirligig words. Congress shall make no law respecting an establishment of religion. No state religion is how that is generally interpreted, meaning we cannot, remember Italy, Catholic, Saudi Arabia, Muslim. They are theocratically aligned governments. The Church of the King in Britain, etc. Right? That is not supposed to happen here. It says so right there, but it wasn't in the original Constitution. The only thing that was in the original Constitution is that there shall be no test. Religion shall never be made a test for office, remember? It doesn't mean that they couldn't have, barring this, establish a religion for the people, only that they couldn't ask religious questions for office. Everybody remember that? Okay. So no state religion. Prohibiting the free exercise thereof. Well, thereof of a state religion? Wait. Thereof what? This is largely interpreted to be that the state cannot restrict your rights to exercise your religion freely. Now, there are some caveats. For example, should your religion rely heavily on human sacrifice, it has been deemed that that falls outside the free practice of religion here, and you will probably be restricted.
Well, they could technically practice it, but then would they just get arrested for sacrificing people, or
Well,
for the crimes
They
related
would
to that?
they would not be arrested for the sacrifice. They would be arrested for the murder.
Yeah.
Homicide.
But then they couldn't. They're not allowed to say, "Oh, but it's part of my religion. I was practicing my religion."
And we've already found a limit, because nobody agrees, to my knowledge, that human sacrifice is a readily acceptable form of religious observance in the United States, or, almost anywhere in the world. I mean, there's like 2 places in the world that still practice cannibalism of any kind. Freely open, India, and India has some.
Some parts.
Some parts. and no, Papua New Guinea specifically. The one I was thinking of. I was not going to say. That's it. So we've already found something that we're willing to limit. We have now 2 limits. Or abridging the freedom of speech. What is a limit to freedom of speech? Because we have limits to freedom of speech. There are things we can't say. What are they?
Cannot incite terror or panic in larger groups of people.
Cannot incite terror or panic or a riot. Inciting a riot is a crime. Mhm. What? Well, yeah, yes, and or no, depending. I don't remember if he was tried and convicted or not. There was a video. There was a video, but he didn't use the word riot. So maybe he was inciting anger. Maybe he was expressing anger. Maybe, I don't know. I wasn't there. I watched the video, though. My opinion is none of your business. But there are limits to freedom of speech. You cannot yell fire in the back of a crowded movie theater in a dark space. Specifically, the dark space matters because people are disoriented in that space. Right? You cannot yell fire in the back of a crowded movie theater. That is one of the examples classically cited as a limit to free speech. You can't do that. It endangers people in daily lives, and it infringes on their otherwise guaranteed rights. Right? Including peaceable assembly. Now, I want you to notice that the right to assemble doesn't have a peaceable clause. Peaceful assembly is not what is guaranteed, just assembly is guaranteed. So now we have to fall back on the Article 1, Section 1, or even the preamble, domestic tranquility. Amazing how often I can cite the legal right to domestic tranquility and the government's obligation to provide for it. At what point do we find that domestic tranquility is at opposition with the right to assemble? At what point do we find that domestic tranquility is at opposition with the right to freedom of expression, freedom of speech, or freedom of religion? Frequently, we are at odds, right? And it falls to the courts to decide matters of law and equity, and these fall into those. All right. Or of the press. What is the press? At the time, it was newspapers. It was anybody with a printing press, because those things were expensive, right? The automated, mechanical, or otherwise industrialized distribution of information, right? Through some standard mechanism, means, or form. However, these days we have many more standards, mechanisms, means, or forms, and forums to distribute messages. Do you consider yourselves to be the press if you have a blog and you talk about the news?
I don't see why not.
I don't see why not. I didn't ask you, would you possibly? I said, do you? When you express your opinion in a public forum, do you consider yourself to be the press or journalism? Or a journalist? You would say yes?
I would be upset if someone tried to limit me.
Well,
Stop me from saying
okay,
something.
so now you're a journalist. Now you're press because you have a little bloggity blog. Cool.
What about
Do you then apply for press credentials to a White House press conference? With a reasonable expectation of achieving those credentials? Being granted those credentials? Not reputable, see? Yeah, maybe you don't have a reputation. There was this guy, he's not dead. Perez Hilton. Celebrity blogger turned supposedly journalist, just ask him. Because he built a reputation in his circle. And if I recall, he did try to get press credentials to the White House once. Almost turned down, and it's a big stink. And Congress is trying to decide that issue, or at least did try it and failed, to decide the issue of, in the cyber era, and a lot of you might want to pick this up for a later essay. In the cyber era, what is a journalist? Can we define press in the cyber era? Can we define press in the mass media era? Who gets credentials and who doesn't? At what point do we draw that line and still maintain our 14th Amendment obligation to treat everyone equally under the law?
social media?
Welcome to social media, that's right. All right. The right of the people to peaceably assemble, it does have a peaceable clause, look at that. And to petition the government for a redress of grievances. There you go. Don't abridge it. So, is anybody familiar with the Death Star petition? The Death Star petition. Yes, I mean that Death Star. Yes, I do. Like, oh my God, it's a moon. That's no moon. Yes.
Let's do this.
Let's do. So you're signing. Okay. There was a petition, and under the First Amendment, fifth clause, meaning fifth blank, meaning right to petition for grievances. There was a group that felt aggrieved at a lack of the United States-owned Death Star. Some of you may be sharing that aggrieved. And they started a petition, and that petition achieved the number of signatures required to force the government, under current regulation, to respond to this petition for a Death Star.
How many is the requirement?
Well, it turns out the requirement was 25,000 signatures.
I'm guessing they bumped it up after this.
It has been bumped
Okay.
to 100,000 signatures.
That's still doable.
That's still
doable.
that's still easy.
I'm sure I can get
I
excited
would-
people
I-
to do that.
There you go. So, with 100,000 signatures, you can force the government to address any question you have. Now, you may not like the answer, but they have to respond. Isn't that fantastic? I'm not aware of, let me rephrase, I was about to say there's no other country. I am not personally aware of any other country that allows the people to force the government to respond to a question by just signing some stuff. That's cool. And they literally had to say, do you guys have any idea how much that would cost? Because they have to give a realistic justification for the rejection of the proposal. And one of the rejections was cost. Holy crap, that would be 10 fortunes. 2, treaties. We're not supposed to weaponize space too much. And 3, tidal waves. It's the size of a moon. Okay? They literally had to respond properly. That's fantastic. There's also another one that was asking to build a Starship Enterprise. I proposed a plan, and they estimate that it would take only $4 trillion. Only $4 trillion.
That's
Doable.
That's a bargain.
Hey, who wasted
That included hundreds of billions for research into warp drive.
Yeah, I was gonna say, is this like including the warp drive and
Yes.
everything? It is.
Yes.
Okay.
I'm all about
All right, let's move on.
it. Let's do one.
Article the 4th, which we now know as the Second Amendment. Describe it to me in one word.
Right, bear arm.
No, that's
Oh.
multiple words.
Okay, guns.
Guns. Amendment 2, guns. We can't have guns. We also say it's the right to bear arms. Other people say it's that gun nut one. Other people say it's outdated and they meant muskets. Seriously, that's what
But they
say.
also, the word militia is used. Is this the one where they talk about the militia?
Yes, and so the National Guard gets guns because they're the new militia,
Yeah,
right? And they are quite well regulated.
because that's what the argument
So let's
is when they-
investigate this. Not that we will solve this issue, because we will not. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. You know, the first time you read it, you're like, man, that's really clear. Except for that militia part, that's really clear. Then you read it again, and you say, well, a well-regulated militia, comma. Is that an Oxford comma? Okay, hold on. Militia is necessary for a free state, secure, and then the people get to bear arms. None of this shall be infringed. That's really confusing.
Yeah. Those comments.
Yeah. Commas? Do the commas have meaning, or were they choosed? This is a huge issue. This is an issue right now. One of those 10 cases that was going to go before the Supreme Court is a gun case. One of those Supreme Court cases is an abortion case, etc.
4 and 4.
4 and 4 on almost every issue.
No, I mean, conservative liberal justices left.
Yeah, 4 and 4. Uh-huh. Yeah, he was the swing vote. Scalia, the one that died was the swing vote in all of these things. The one that died is the one that is likely to be responsible for the decision.
Was it old age, I suppose?
Nobody knows. We're not going to talk about that.
Somebody said they found a pillow on his head.
The guy who found it said there was a pillow on his head. That is true. All right. We are not going to solve the Second Amendment except for the question, because we're going to find the cyber relevance of all these things. We're not going to discuss the cyber relevance of the first one, because that's actually part of your assignment coming up this week. The cyber relevance of the Second Amendment, or Article the 4th, as it is affectionately known to founding fathers. What is it? Is there a cyber relevance to the Second Amendment? You think there is? Why?
Because
Online guys, feel free if you think there's a cyber relevance, type it in. Second Amendment, cyber relevance. Cyber relevance.
Digital weapon.
what? Honestly, well, yeah,
Digital weaponry.
a small group of people with the knowledge, with the willingness and ability to cause massive amounts of harm.
Okay, so are computers weapons of mass destruction? Because there was a headline last week that the internet itself is a weapon of mass destruction.
I mean,
And it is true, it is absolutely true, and this is where my actual research is in cyberkinetic attacks, that a talented teenager with a $500 laptop can literally wield the power of a nation state with enough time and talent. Not even dedication, just time and talent. Okay? They can literally, let me say that again, they can literally, in the cyber arms race, wield as much power, the same level of power and sophistication as a nation state currently. There has never been a time in history where an individual was capable of wielding that much power with so little resources at hand. Terrifying. Do they have a right to do that? Should we be taking everybody's computers away because they might cause damage? Should we be taking everybody's car away because they're hackable? That one's less certain.
yeah.
Right? No, we're not going to take all the computers away. But do we have a right to cyber weapons? Do we have a right to attack back when we're attacked? When we're being attacked by a hacker, do we have a right to hack back? Because face to face, if one of you walks up to me and punches me in the face, I'm allowed to punch back. That's just how it is. 1, why were you so rude? 2, self-defense. Online, how do you attack back? Do you have a right to attack back? This is a serious question, because what happens if you attack back, but the person you attacked wasn't actually responsible for the attack because their computer was zombified in a network of botnets? And you attack back and you're taking out somebody who was not actually at fault for the attack. It's really complicated. I'll just wait until we get to self-driving cars. We're going to talk about that.
Did they just, I just saw something the other day about, like, where they just determined that the car is the driver, because there's that whole debate, like, if you're riding it in, there's no driver.
That's completely undecided.
Oh, it is?
That's
Okay.
completely undecided.
What are the arguments, I guess?
The insurance company wants the car to be the driver. Okay?
Yeah, because then...
The other person's insurance company wants the passenger to be the driver.
But then if the car's the driver, do they not...
We're going to talk about that. That's a whole day.
Yep.
That is a whole day. That's later. We're never going to get through this if I do that. That is a whole day. All right. Which brings us to the Fourth Amendment, which is one that we don't think of much. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. This was a huge issue. If you recall back to your Revolutionary Era history, or if you've never had Revolutionary Era history, pay attention. Because at the time of the Revolutionary War, Britain was quartering. It was called the Quartering Act, and they were forcing owners of households to host soldiers in their homes, in their beds, next to their daughters, eating their food. They were forced to clean up after, to feed, to house, and do everything else. They were going broke, keeping the British Army alive. And the British Army didn't have to spend a penny because, oh, Quartering Act is the law. And the soldiers could come in and take anything they wanted without the consent of the homeowner, because the protections of a person's kingdom, being the house being their kingdom or their castle, depending, that applied in Britain did not apply in the colonies, because the full force of British rule and rule of law did not apply in the colonies. They made special laws that were different and distinct from those laws that were enforced upon their own people back home. Now I want to see, does anybody have a cyber relevance for the Fourth Amendment? I did. I did. There is a potential cyber relevance. We don't hear about the Fourth Amendment much, because when was the last time the government tried to stash a soldier in your house?
It's been a while.
It's been a while. It's been a couple days. It's been a little while since that happened. Or it's happening right now. Because what is a soldier?
I was gonna say a weapon. That's not really a good.
A weapon?
A commodity to the U.S. Yeah. An employee.
It depends on how you see them. If a soldier can only be defined as a breathing, living human, then you're right. They're not quartering anybody at your house. However, if a soldier can be defined as an automaton for the government, or something that only follows the orders of the government for military purposes, or something that is employed by the government, managed by the government, or something like that, then what happens when the government drops, say, a listening program on your computer without a warrant? What happens when the government, say, enlists the secondary computing power, when you're not using your computer, to process transactions, to process research, to process and perpetrate cyber attacks against foreign nations? And, oh, they didn't come from us, which, hate to break it to everybody, happens on all sides of that line. What happens? Is that quartering? Because who's paying for the power? Who pays for the power on your laptop, on your computer? You, for the most part. I mean, you might be here and you're getting free power, although you pay for that too, because one taxes to tuition, right? But it's your resources, your computing cycles. Computing cycles are valuable things in this era. We waste a lot of them, but they're very valuable.
I got in trouble because he hacked into the network for a large gaming system and used all their spare computer cycles to
Mine bitcoins?
Bitcoin.
That's fantastic. He probably has to turn over all the bitcoins he earned, because he earned them ill-begotten. Those are ill-begotten gains, and can be forced to turn over to the government or to the individual from which they were taken, depending on how they approach it. All right. I just want you to think about that, because we don't think about the Fourth Amendment much. The right of the people to be secure in their persons. This is right after the Quartering Act. Secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This is one of my favorite ones. Right here. Oh, I'm sorry. This is the fourth one. We're going to think about the third one.
Okay, I was confused. That I thought I missed a whole amendment there.
You can call me on it. This is the Fourth Amendment. What is this one usually called? Online guys, what is the Fourth Amendment usually called? Almost all of these things have names. Somebody, what's it called? You can type it or say it, don't care. We will wait. Fourth Amendment. No.
No search without a warrant.
Yeah, that's one of them. That's descriptive.
Unreasonable search and seizure.
Some people call it the probable cause one. Some people call it the warrant one. Some people call it the you're not searching my car one. There's no actual name for this one. It's search and seizure. Okay? And it's one of the most important ones, and it's the one that we're encouraged as the population to give up easily. Make my job easy. Come on, man. You got nothing to hide. That happens, right? Normally I'm wearing a police hat, right? Today I'm not. Tonight I'm wearing a different hat because it matched my shirt. The police hat didn't. But it happens. That is a tactic, right? Lots of us don't like dealing with the cops. If I'm not wearing that hat, I don't like dealing with the cops. I hate to break it to my cop friends. You're a pain in the butt. And this gives me the right to tell you to leave me alone, write me the ticket or let me go. Right there. It also specifies some things. And these things are important because in the previous time, when this was written, your papers, your person, your effects, they were all tangible things. I could touch the paper. I could hug your person. I can kick your effects. How much information, how many things are on your computer? A lot. Depending on how prolific you are, a lot. Because an author, for example, back when this was written, their papers might be their life's work. Sir Arthur Conan Doyle, not an American, but prolific. Quite an author, and if somebody were to have seized his papers, they would have seized some wonderful characters. They would have seized literary genius, taken it from him, and it would be hard to recreate if it was his only copy. What about you? If your computer is taken and you haven't backed up lately, like most of you haven't, how hard is it to recreate?
Time consuming.
Very time consuming, if it's even possible. Because sometimes you write that perfect introduction. Sometimes you write that perfect essay. I know I've heard about the perfect essay many times. I swear to God I had it. But sometimes it's impossible to get those things back if they disappear. And back then, it was papers, it was physical things, it was easily identifiable. Now it's digital. Things are digital. You can't touch digital. I have no idea. If you were to take my contact list from my phone, holy crap. He knows that's a valuable contact list. I'm not even worried about not being able to call people, right? Because I still remember lots of phone numbers. I can get in touch with some important people. But if you take my list, so can you. It's bad. That's not a good list to get out. You probably have some numbers you don't want me to have too. Right? There's some people going to be really pissed off with me if you take my phone and my contact list. And I don't want them mad. It's not a good situation to be in. And how that works out now is very difficult. Especially since, for example, the Patriot Act. The Patriot Act changed a lot of things. And it didn't just change it for personal, tangible effects. It has effects in cyber. I don't want to discuss that too much. I'm giving you a seed so that when I give you the assignment at the end of this lecture, you might come back to that. The Patriot Act and the Fourth Amendment are definitely cyber relevant. All right. No person shall be held to answer for a capital or otherwise infamous crime. I love the phrase infamous crime. Unless on a presentment or indictment of a grand jury. Keep in mind the grand jury is the grand jury system has been under question lately. Do we even need a grand jury? Well, yeah, actually we do, because the Fifth Amendment says we have to have a grand jury, or we can't indict anybody. Except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Wow. That is action-packed. What is that one normally called? It's usually just called the Fifth. I plead the Fifth. It's also called due process. Because that's the one thing that all the clauses in here have in common, is due process. It establishes, yeah, see, plead the Fifth. It establishes due process. And from a legal perspective, this is incredibly important. I would also like to point out something here, because these days we are, what's the word? I hesitate to use the word soft, but we are wishy-washy on the concept of the death penalty as a society. We are definitely not into dismemberment as a punishment. Huh? Yeah, that second one, not all of you feel wishy-washy on your stance on the death penalty. But most of you don't want to be dismembered for anything. You'd rather die. Just shoot me. I'm sorry. Whatever, right?
I don't think I did anything.
Cut off my hand, right? In some places they do. But right here it says, put twice put in jeopardy of life or limb. That's often overlooked because there's also this one that we're about to get to called cruel and unusual punishment. That's what it's normally referred to as. And in there, if you can have your life or limbs in jeopardy, and it's recognized in the Constitution right there, well, punishments used to be a little different, although I'm not sure that limbs in danger was actually common ever. I think it's probably a turn of phrase, but that doesn't change the fact that life or limb are in here. And this is odd because double jeopardy is applied to every single charge. Every single crime, you are given the protection of double jeopardy. You may not be tried for the same crime twice, is how this is interpreted, even though that's not what it says. It says you can't be tried for a crime for which life or limb is the penalty.
Is the crime intentional? Still, that person can be charged.
What's that?
If the crime is intentional, like
Yes, if you are charged with a crime and not found guilty, that you didn't have enough evidence, at the end of the trial, you can literally, after the jury has read the verdict and it has been registered, at the end of that trial, you can literally stand up and say, guess what? You all suck. I did it.
I was bluffing.
Yeah. I win, you lose. It's not smart.
It's not good for your civil case.
It's not good for your civil case. But you can do it. And that's that. There's movies. The movie Double Jeopardy is great because she's already been found guilty for and served her time for a crime she didn't commit. And now she can legally commit the crime. Great movie. Or at least that's the substance of the movie. Whether or not she can actually commit the crime is in question. That's not necessarily true. Right?
Which movie it is?
Double Jeopardy. It's called Double Jeopardy. Ashley Judd. Yeah, good times, good times. So we're supposed to be secure in all these things, and we're also not to be held to answer for capital or otherwise infamous crimes unless a grand jury. So smaller crimes, non-capital, non-infamous felonies is usually federal felonies, right? Federal laws, etc. But misdemeanors, not so much. High crimes and misdemeanors, that's a Congress thing, right? And those are committed inside the federal government against the federal government. That's a high crime, right? But here we're talking about you and me. This is a protection for the people. This is how we are to be treated, how corporations and businesses are to be treated, because Citizens United, for example, they're people too. Which is, we'll get to that. We will get to that. And my opinion on that one might surprise you. Let's see. Making sure I'm not missing anything. Oh yeah, you can't be compelled in a criminal case to be a witness against yourself, and you guarantee due process of law. Now, due process of law could mean lots of things, but what it really means is that they have to follow whatever rules are in place, and they have to treat everybody the same in accordance with those rules. Did you know that you can force your trial to happen? You have the right to a speedy trial. You can force your trial to happen within 30 days or less. And if they refuse to try you within 30 days, you go free.
Sure.
Most lawyers say we need time to build a case, and they automatically ask you to waive the right to a speedy trial. Little interesting tidbit.
But you don't waive your right to speedy trial.
If you don't waive your right to a speedy trial, you can force them to try you in completion in 30 days or less. Which is sometimes very
Wait,
smart.
incompletion?
Like
like-
completion, you have to. They have
They
to finish
have
the trial.
to sentence you. You have to be like have a verdict.
Typical felonies,
Sentencing
so 4
is
days
separate
or
though from a trial.
Huh?
Well, not sentencing. They have to come up with a verdict within those.
They have to be sent to obtain a verdict.
Okay.
Because the jury can deliberate as long as they want. Typically. The right to a speedy trial is not typically exercised. What? In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Look at there. By an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. There's a lot in that article. And it is the bedrock of criminal prosecution. 1, you have the right to a speedy trial by an impartial jury. If you can show that your jury was not impartial, you can move for a mistrial, which sometimes results in complete dismissal. Otherwise, it results in a retrial. And it's supposed to be where it happened. If you cannot obtain a fair and impartial jury where it happened, you can petition for a change of venue. And the law describes where that district shall be. You have the right to be informed of the charges against you. Because in some countries, that is not the case. You can go to court and never know what you're being charged with. Seriously.
That's true.
Yeah, I know. But it's just.
Rot in jail for nothing.
Yes, you can rot in jail for nothing. You can be convicted without even knowing what you were charged with, just by they give you the classification instead of the details of the crime. In other countries, they say, you've been charged with heresy. When did I do that? Heresy is not a thing in the United States. I picked one that isn't. That's not here. Okay? But you've been charged with heresy. Well, I don't remember doing that. I'm a practitioner of the faith of the country, and that, what? No. Over there, not a thing. Whichever over there you pick. Okay? Where they don't have the right to a speedy and fair trial. Or to know their accusations. You have the right to be confronted with the witnesses against you. This is controversial. Why is this controversial?
Witness protection.
Well, witness protection doesn't stop them from going to the trial. That's one of the reasons it exists. Because you have to be protected so you survive long enough to testify.
Victims' rights. You
Yeah.
have to relive the situation.
Back in this, there is no such thing as victim's right because the British government at the time was so oppressive, so overbearing, and so eager to prosecute even the innocent, and you had to prove your innocence as opposed to having your guilt proven, that these laws are written to protect the innocent even at the cost of setting the guilty free. That is how these laws are written. And it was a sign of the times, and not everybody agrees with this in every case. For example, it's easy to see where an exception exists here. In the case of child abuse, specifically child sexual abuse. Which among us has the heart to force a 6-year-old girl or boy onto the stand to confront the person who raped them repeatedly? Or get cross-examined by a person with no soul? That's a thing. Go watch Devil's Advocate. Also a good movie. Yep, Devil's Advocate.
Cool.
It's on Netflix right now.
Fair warning.
We're all adults. And it is rated R. Yeah. You have the right to confront your accusers, and it doesn't matter who that accuser is or what witness they bring. You have a right to look them in the eyes according to the law right here. And that is controversial because of victims' rights, because of empathy for the victim, because back then, child rape was not one of the things they were thinking of when they wrote this. Because what happened to a child rapist in 1789?
They were strung up and
Huh?
Pretty much killed on the spot.
Yes, they just died miraculously, fast, slow, depending on who got hold of it. Okay? Yeah, that just happened. Okay? And yes, they had the right to due process. No, it didn't always happen.
only from the government.
That is true. See, and then the government has to choose whether or not to bring charges, and that is still the case. The government still has to choose to bring charges against the person even now. They usually will, just in case you're thinking about doing some vigilante, they usually will bring charges. But it's still a choice. All right, Article 7, also known, or Article 9, also known as Movement 7. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by jury shall be otherwise re-examined in I can't talk now. I was listening to people in the hallway. Pardon me. Shall be otherwise re-examined in any court of the United States than according to the rules of the common law. In other words, follow the appeals process, if there is one. And common law is for normal things, right? It's also civil law. Remember? That's all covered in that glossary and dictionary. Okay? $20. Does anybody have pull up an inflation calculator? Find out what $20 in 1789 is worth now.
I didn't think about that.
Oh yeah. Oh yeah. You want to see a traffic court judge get really pissed off. You want to make them the angriest you've ever seen a public servant. Ask for a trial by jury when the fine is under $100. Demand your constitutional right to a trial by jury because you are not going to pay $21. I would also like you to know what?
$496.86.
$196?
$496.
$496. That sounds more jury worthy. $500, yeah.
12
Okay.
people $6 a day.
Yep. There you go. Yeah, you will really anger that person. I would also like you to note that in my county growing up, the court fee to get your ticket dismissed was $20. You bastards. Just saying. All right. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Okay, everybody knows about excessive bail, and what's excessive for one person is relative to what's excessive for another person, blah, blah, blah. I don't care about bail. Bail, I mean, if you had to find one that doesn't really have much cyber relevance, bail. Until they start accepting bitcoins for bail, it's probably not super relevant. However, cruel and unusual punishments. First of all, I'd like to take a computer science approach to this issue. What is the operator in that sentence? In that statement? Huh? Anybody? Yes. Thank you, Mark. And. Not or, not nor. And. Cruel and unusual. So in theory, it could be cruel or unusual, but it can't be both. So, for example, have you heard of the people who go to court and they get found guilty of theft, shoplifting? And the judge, the trial judge, takes the unusual step, unusual, to force them to wear a placard in front of the store from which they stole, saying, "I am a thief, berate me," or whatever the judge wants it to say. Is that particularly cruel?
No.
No?
No. Not by general standards, right? I mean, you're not getting beat up. You're not getting.
Not in jail.
You're not being dismembered, right? While it is a terribly unusual penalty, it is not particularly cruel. The death penalty. Is it cruel? Many people consider it cruel. However, according to the Constitution, it doesn't meet standard because it is not unusual. It's not hanged. And, you know, I don't care who you are or what you did. It is, you have to be cruel to kill someone. It is a cruel thing to do. Although arguably there are, you know, euthanasia examples. But that's not what this is about, right? So there is definitely a cruelty to the act. But if it's common at punishment for a given crime, it is not unconstitutional, regardless of what people would like this to say. And And many times we've had this discussion. Now, if society chooses to abolish the death penalty because it no longer fits our social mores, that's fine. But they can't rely on the Constitution to back them.
Are we on the 8th Amendment right now?
Yes.
Okay, sorry.
Yep. What?
If they're convicted of cybercrime, the judge banned you from sitting on computers or.
That's a good question. And that's possibly a cyber relevance. If you were convicted of a cybercrime and you got banned from a computer, which happens, that is not an uncommon penalty for computer crimes. You can be told, no more computer for you. And to the standards of the general population, that is not terribly cruel. Just like wearing a placard, right?
But it is cruel in the eyes of the person who's being punished.
Well, that depends,
In most
because
instances.
are they a cyber-dependent person, right? If they grew up and their only connection to the world is digital, they live and breathe through a keyboard, they whatever, blah, 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 whatever they want to describe it as. Huh?
Keyboard warrior.
A keyboard warrior, sure. However you want to describe it, it is possible that you are being cruel to that person. And I wouldn't doubt that we see a case on whether or not suspension of computer rights, computer privileges, shall we say, becomes a case under that clause. Is it cruel and unusual? Well, it defines a computer, yeah. Is it cruel and unusual to take away somebody's cell phone when they're addicted? Cell phone addiction has been shown to be an actual thing.
Is it on your Xbox?
Is it cruel and unusual to take
Is there
drugs
a
away from
fee?
an addict? Because if we don't do it frequently, if we don't take your drugs away, yeah, it might be cruel and unusual. All right. I just like to focus on and there because they knew how to use the word nor. It's used right there. Nor cruel and unusual punishments. They knew how to use the word or. It's here too. And they picked the word and. It's important and it's frequently used, especially in a cursory glance at these rights. Okay, Article the 11th. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. In other words, there's no possibility, no possible way that we can enumerate all the rights that the people have. We've tried to enumerate a few that we consider to be important: speech, religion, guns, process, freedom of searches, due process, non-incrimination, etc. We think these are important things. We know we missed something, and just because we didn't say it doesn't mean that people don't have it. Doesn't mean it's not a protection. What's a right that is commonly considered that is not specifically enumerated that we have? And in fact, the Supreme Court has decided on the basis of what is a right that we have? Anybody? It has not been enumerated, but it cannot be taken from us, and it has been, and there is precedent for it. What's missing from the document that we hold great in this country? Why can't you just come into my house whenever you feel like it?
Privacy?
Oh.
Yeah, because it's private. Privacy. We have a right to privacy. Roe v. Wade was not decided on morality. Roe v. Wade was not decided on religion. It wasn't decided on anything else. It was decided on a recognized constitutional right to privacy, extending to the tradition of medical privacy. They completely avoided actually discussing the issue by saying it's none of our business. And that is protected under that 9th Amendment. And the 10th Amendment. The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. In other words, the federal government is only supposed to do what's in this document and the subsequent amendments that we haven't covered yet. And everything else belongs to the states or the people. That's how it's supposed to be. Let's continue. Any questions so far? Online guys. Blake, welcome. Awesome. You doing all right? Any entertaining tidbits? Added to your knowledge at all? Awesome. Sweet. Let's continue, because I know you guys want to get done. So do I. We can home and see the wife and the baby. Results in the House of Representatives. They were then ratified. Became the amendments. Continuing on, and we're done.
So the way they passed through Congress.
Congress passed them as resolutions for amendment. They were sent to the legislatures, 3/4 of which, by a 3/4 vote, ratified. Now, that was a lot easier back then because there were only 13. Right? Okay. All right. Bill of Rights, 1127. All right, the 11th Amendment. Note, Article 3, Section 2 of the Constitution was modified by Amendment 11. It's odd that the Supreme Court was the first thing modified after the Bill of Rights. Early. 1794, they're like, hey, we screwed up. 1795, everybody agreed. That's fast. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. This is very important. In 1994, Yahoo would be sued by France. And under the 11th Amendment, the Supreme Court told France to stuff it. There you go. This one can be very important. I just gave you a cyber relevant case example. Right? Feel free to look it up.
What do you mean a foreign state over like new country or something?
Yeah, France is my example. France tried to sue Yahoo. Yahoo is an American company owned by American people and manned by American citizens and incorporated in the United States. And it falls under United States law. France tried to force their laws onto an American company by suing it inside the United States. And they were told to stop it based on this amendment. It was not a very in-depth decision in terms of length. It was one of the shorter decisions I've read, and none of them are short. Hopefully, when you were learning, doing your first case brief, or maybe not learning and just doing a case brief, hopefully you noticed that the cases are long and take a lot of reading. This is a law class. It is reading intensive. It's not nearly as writing intensive as it could have been. All right, Amendment 12. Note, a portion of Article 2, Section 1 of the Constitution was superseded by the 12th Amendment. That's so much writing. The electors shall meet in their respective states and vote by ballot for the president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballots the persons voted for as president, and in distinct ballots the person voted for as vice president. This gets rid of the original provision that the president and vice president would naturally be and must be from separate parties, so that whoever wins first gets president, whoever wins second gets vice president. And that is because by 1803, when this was submitted, and 1804, even more so when it was ratified, there was already a two-party system coming to view. And this two-party system was showing that a president of one party and a vice president of another party were not a good thing in terms of continuity of leadership, in terms of continuity of ideas, in terms of voter representation of those ideas in office. It certainly does open up the precedent to assassination. Because already, remember, 1776, we go to war. 1783, we're independent. 1789, we get this Constitution thing in order. 1804, how long has it been? Since the Revolutionary War. 21 years since we've been independent. How long is a human generation typically? 20. 5 generations. Especially back then, it was totally plausible that every 20 years a whole new batch of people would be up. So now we have adults coming to power, coming of age, for whom Britain has never been a sovereign, for whom the United States has always been a thing, for whom party lines have been a lifelong obsession. This is how it happens. In a university setting, every 2 to 6 years, depending on whether we're talking grad school, undergrad, or slow people, by which I mean people who usually work their way through college like I did. I spent 6 years in undergrad. And so I was one of the slow ones. But every, usually 4 years, we have a complete turnover. Everybody is new. I call them the temporary people. You guys, for the most part, will be temporary people. I will be a temporary person in your life unless you continue to reach out to me after you graduate. You will be temporary people in my life unless you do that. Right? Because I can't make the effort to keep in touch with every single student I've ever had. 1, I don't want to talk to everybody I've ever had. Yes. 2, that's exhausting. I wouldn't have time to actually do my work. Here, we have complete turnover. Some of the founding fathers have already died. They're not all on the same team anymore. What's that?
Probably a lot of them.
A lot of them, yes. Yeah, because they weren't young to start with. And so what you have is you have lifelong memberships in 2 teams now, coming to power, coming of age, and not knowing any different. When the Founding Fathers made the Constitution, they were all on the same team. They all fought the British together. They all had a camaraderie that is not extant in the next generation. And this amendment, it seeks to address that issue. It also reorganizes the Electoral College, and we are still suffering. And by I say suffering, I mean people are still complaining about the Electoral College, even though nobody has actually presented a workable, better solution. It's just like the mousetrap. There isn't an actual better mousetrap. Not until we get laser guided missiles. The rest of this is the establishment of the Electoral College and was superseded by Section 3 of the 20th Amendment, so we're not going to go through this. Okay? This one's not super cyber relevant. Amendment 13. Feel free to read it, though, if you're interested in the history of the Electoral College. Amendment 13. 1865. It's been a while. We haven't changed anything in a while. Look at that. And, oh, wow, ratified really fast within the same year. A portion of Article 4, Section 2 of the Constitution was superseded by this. Neither slavery nor involuntary servitude except as a punishment for crime. By the way, recognizing servitude as a punishment for crime, which was later ruled cruel and unusual, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2, Congress shall have the power to enforce this article by appropriate legislation. No slavery. It's right there. No slavery, no forced servitude, no nothing. And Congress can do whatever they want about it. Unless you are being sentenced for a crime, that is the only way you may be held to servitude. You may choose to leave at any time after that. Okay? This was both a moral imperative at the time and a tactical decision. Please do not think that this was just altruism. This was a tactical decision because the Civil War is hot and heavy when this happened. This was proposed as not only a moral imperative, which it was, but also as a tactical decision to try to make all of the blacks in the South, all of the slaves who, as of this date, are former slaves, according to the Union, rally behind the Union and fight against the South. What's that? Yes, the movie Lincoln is all about this. Amendment 14. Article 1, Section 2 of the Constitution was modified by Section 2 of the 14th Amendment. The 14th Amendment, you will hear cited a lot. Anybody want to tell? Mark, you're batting 1,000 so far. What is the 14th Amendment known as? It doesn't have to be Mark. It doesn't have to be Mark. Anybody else can answer too. Anybody in here? What's the 14th Amendment known as? What?
Equal rights.
Equal rights. It's usually called equal protection. Because it's not equal rights. We all have the rights. It's protection of those rights. It's equal protection under the law. If the law applies to you in one way, it has to apply to me in that same way. And it has been used for a myriad of decisions, but it's not the only thing in this amendment. Section 1, all persons born or naturalized citizens have the same rights, unless otherwise explicitly defined, in the United States, and subject to the jurisdiction thereof, meaning that it happens in the United States, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. A lot of people just stop right there. A lot of people just say equal protection, I got it. Equal protection of the laws. Got it, I understand this amendment. And for the most part, you would be correct. But wait, there's more. Section 2, representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. No taxation without representation. If you're an Indian who's not taxed, you're not counted. But when the right to vote at any election for the choice of electors for president and vice president, remember choice of electors because the people don't vote for the president, electors do, of the United States, representatives in Congress and the executive of the judicial officers of a state or the members of the legislature thereof is denied to any of the male inhabitants. Oh, wait. Male inhabitants. And specified, sorry ladies, no vote for you yet, of such a state being 21 years of age. Wait, when did we vote? We voted 18. This says 21. Okay, we're going to keep going. Keep going. All right. Yeah, it's my fault. And citizens of the United States or in any way of race except participation in rebellion or other crime. In other words, if you are rebelling against the United States, you're not allowed to vote because you, well, you're probably a member of the Southern Forces at the time it was passed, roundabout. And or you, you know, you're trying to foment insurrection. But it also says other crimes, which is how we deny felons the right to vote for him. Until they fully paid their debt to society, and we frequently parole them before they're allowed to finish paying their debt, and that parole gets extended from time to time, and that keeps them from getting vote. Because they're not done with their debt to society. And most of them are more than happy to tack on a couple extra years or decades to their parole to get out of prison. Yeah, can't blame them. Or other crimes based of representation therein shall be reduced one portion, blah, 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 male citizens. Okay. Section 3. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid to comfort of the enemy, blah, blah, blah. But Congress may, by a vote of 2/3 of each house, remove such disability. I have to breathe. If you were in the Confederate military, government, or anything else, you may not run for office unless you're really popular. You're probably not very popular. And I'm actually not aware of any case where this happens, so feel free to find one. Section 4, the validity of public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion. This seems to be a theme here. Shall not be questioned, but neither the United States nor any state shall assume or pay any debt obligation incurred in aid of insurrection or rebellion against the United States. In other words, we're not paying the Confederate War Bill or any claim for the loss or emancipation of any slave. You also can't own people, so we're not paying you for them either. But all such debts, obligations, and claims shall be held illegal and void because it was wrong and you're being punished. Both. Section 5, Congress shall have the power to enforce by appropriate legislation the provision of this article. Now, I want you to note that that's 2 amendments in a row that give Congress the direct authority to enforce it. That's a theme. We're going to see some more themes emerge the farther into this we get. Okay? Because they start to say, wait a second, that thing that said the states get anything that's not enumerated. So we have to make sure that the federal government gets this one. Because it has to be enumerated. Okay? Amendment 15, passed by Congress February 26, 1869, and ratified February 3rd, 1870. That one's also fairly quick. The 15th Amendment. The right of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Congress shall have power to enforce. Wait, didn't the 14th Amendment do that? If you look back, the 14th Amendment was supposed to do it, but southern states and other persons at the time were finding ways to exclude blacks who were supposed to already have the rights. And so the provision was explicitly provided that race, religion, creed, etc., none of these shall be valid reasons for denying the vote. What is conspicuously absent is gender. Because we will emancipate slaves at this time. We will include everybody. We'll get rid of all, we're damn near trying to outlaw racism, but misogyny. That's still cool. We like misogyny still. Women, they can't vote. They don't have brains. That's what's right here. I've always found it very interesting that they managed to stay that entrenched that long. Because if you go back and you read some of the diaries of the time, women were very powerful. Women had, they had control of the households. They frequently had control over money and were able to spend the money as they saw fit. Regardless of whether their husband made enough to spend that much money, they could do these things. They could exercise free power and will in anything but government. Now, there's lots of places where they were still excluded and whatnot, but the government was very careful not to include women in the decision-making process for a long time. Old habits die hard. Amendment 16, passed by Congress July 2nd, 1909. Hey, it's been a while, almost 40 years. And it is more than 40 years until it's passed by the legislatures. This one's, it took a little while. Notice that? It took a little while for this one to ratify. Why is that? What's this one about? It enumerates something. Some people say it wasn't actually ratified properly. Just in case that matters. Huh? Some people say that they didn't actually wait for the legislatures to chime in before signing it on the books. And that some of the records have gone conspicuously, mysteriously missing for that time period, because this establishes something that is still controversial. It makes everybody pissed off this time of year. Taxes. Previously, the right to, the power to enforce taxes and levy taxes and whatnot on various things was established in the Constitution. Congress can make laws about taxes and stuff like that, right? But there was something that was left out of those taxations. What is it? Income. Prior to 1913, your income was wholly your own. What is on the horizon in 1913? That's right, the Great War. The last war. The only war. The war that nobody wants to see. The war that's going to end everything. The war that destroys Europe. The war that destroys a generation in France. The war that does pick your thing. It did, according to the papers of the time. But the smart people, crafty people, and various other wordy people in Congress and in power at the time said, we don't have enough money to go to war, and if Germany wins, they're coming here. So why don't we make sure that we can support a war effort? Also, we've got a good economy. Why don't we take a piece of that? Because there's lots of government things, lots of military things, lots of this, lots of that, lots of the other. Oh, and we also don't have the money to regulate our railroads properly, so maybe we want to work on that. Yeah, let's do that. Let's tax incomes. Well, and in the 1970s, the income tax was over 76% for the top tax bracket. So things could be worse. Article 1, Section 9 of the Constitution was modified by Amendment 16. Congress shall have the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. It is levied on individuals and businesses. It doesn't matter how many people are in what state or whatnot, because the federal government is not required to give any of it back. And in the previous taxation mechanisms, they were required to share. Next. 17th Amendment. We are running through this. What time is it? Hey, if the broadcast stops anytime right about now, I apologize, because this is about the time when it quit last week, so we're going to try to speed through this. What? Yeah. The Senate of the United States shall be composed of 2 senators from each state elected by the people thereof for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such a state, this is where gubernatorial appointments are established, shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill vacancies by election as the legislature may direct. In other words, they most of them went with just appoint somebody until the next election. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution. Chosen is spelled with an O. Not choosing. All right. Amendment 18. Section 1, 3 parts.
Congress shall have.
It doesn't, does it? It doesn't say Congress shall be able to legislate this. It just is. And that means that they're not supposed to modify it at this point. They're not supposed to construe or maintain how it is. And only the state legislatures have to. Amendment 18, Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, let's call this the you can't have any fun one, because this one was repealed. This is prohibition, and I don't think this is one of the few amendments to the Constitution that is specifically and directly repealed. You know what? That's an important historical lesson. In the time of Prohibition, there was a strong movement, right? It was the temperance movement. And the temperance movement had a moral righteousness to it, and emotional righteousness to it. And it's really hard when you see somebody who you think is respectable, who you hold in esteem, and whose opinion you value, because you believe them to be, and they probably were. Their intentions were good and pure to the best of their insight. And some people still think maybe it should be a thing that no drinking allowed. Okay? And I don't care how you feel about the issue, because it's been decided. I guess you could try to push for temperance movement back in. But what happened is there was a very strong moralistic and emotional push, which we have seen in other issues around the country. It's really hard to say no to. In the Republican Party right now, it's really hard to stand up to anti-abortion persons because they have moral righteousness on their side. And on the Democrat side of the aisle, it's really hard to be a pro-life Democrat because they have moral righteousness on their side. Because it's the choice and it's the decision and it's freedom. Even though one side of the aisle touts freedom and wants to restrict choice, and the other side of the aisle touts public support and the government knows best and then wants to say freedom matters. That doesn't matter because it's really hard to stand up to that force of moral, of righteousness as it's seen and perceived by the perspective of both sides. And they managed to get such a force of movement and gain so much momentum that they would shout down any naysayers. And that's how it got passed. And it's a good thing that they were only after alcohol because they had such righteousness, and such momentum behind that righteousness that they could have passed almost anything. And then this happened. Parentheses, no, never mind. That's just when we get the vote.
Just, well, yeah.
Yeah. So in the interim, because the temperance movement was largely pushed by women, it was largely manned by women, and I say that tongue in cheek. Women were at the forefront of the temperance movement, and it was the most political power women at large had ever wielded in the United States, and they rode that into the suffrage movement. And women's suffrage became a thing. 1919 passed Congress, and 1920 was ratified. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have the power to enforce this article by appropriate legislation. Hey, look! Congress has the power again. Probably did a trend. And 20. Article 1, Section 4 of the Constitution was modified by Section 2 of this amendment. In addition, a portion of the 12th Amendment was superseded by Section 3. Section 1. The terms of President and Vice President shall end at noon on the 20th day of January, and the terms of senators and representatives at noon on the 3rd day of January. It's taught that they are not the same. Of the years in which such terms would have ended if this article had not been ratified, and the terms of their successors shall then begin. Section 2. The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day. Don't they still meet then? Pretty sure they do. Section 3. And by the way, they have the power to appoint a different day, but they don't have the power to appoint a different taking of office. That's where the term starts. So if you get elected, if you've ever started a new job and you wondered when your start date was, it's right there. Read your manual. Section 3. If at the time fixed for the beginning of the term of the president elect shall have died, the vice president-elect shall become president. If a president shall not have been chosen before the time fixed for the beginning of his term, or if the president-elect shall have failed to qualify, which can happen after election. You can be disqualified by Congress after election. Remember, Congress has the ultimate ability to qualify candidates. And then Congress may by law provide for the case wherein neither a president-elect nor vice president-elect shall have qualified, declaring who shall then act as president, or the manner in which one shall act shall be selected, and such persons shall act accordingly until a president or vice president shall have qualified. So if a person aged 34 became elected, they would not be able to take office until 35, and so Congress could either disqualify them wholesale or get somebody in temporarily, assuming vice president couldn't take office, until that person reached age if Congress wished to further qualify that person. It would never ever happen, but it could.
It's a big deal when Bush got elected. Al Gore, I was watching Al Gore sitting there telling the President of the Senate he's coming to sit down and not talking about this thing.
What date does the presidential election end? Like, when is the president-elect decided?
November.
Something?
Thanks every year.
Okay, November. Okay, so if
It's the
somebody,
first Tuesday.
so like, if somebody with a December birthday was 34, like, could they run and not even have it? Is the 35 requirement?
35 by the day they take office.
Okay, by the day they take office. It's not, you don't have to be.
That's the general interpretation of the Constitution, because you are not president until you take office. So on the day you swear your oath of office, you have to be 30.
So you can be president-elect.
It has
at
never
34.
been an issue. We have never elected anybody in their 30s. Okay? And the likelihood of it happening in the near term, very low. That would have to be a really charismatic person. Section 4, Congress may by law provide for the case of the death of any persons for whom the House of Representatives may choose a president whenever the right of choice shall have devolved upon them, and for the case of the death of any of the persons for whom the Senate may choose vice president whenever the right of choice shall have devolved upon them. In other words, if people just keep dying, Congress picks. Section 1 and 2 shall take effect on the 15th day of October following the ratification of this article. Section 6, the article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislature of 3/4 of the several states within 7 years from the date of its submission. That's new. So you remember that amendment that's just hanging out there?
Oh, yeah.
There's only one left because now we've passed one, but there were two just hanging out there. And the legislatures of each of the states can pick them up at any time. And their votes, once they ratify it, unless they revisit it and de-ratify it before it passes the vote test, 3/4, can pass. So one state could have ratified that salary amendment in 1789, and that ratification vote sticks through 1992 when it finally does get ratified by a sufficient number of state legislatures. That is crazy. And this addresses that. They say, hey, 7 years. We don't want stuff hanging out for 200 years. We still have stuff hanging out for 200 years, and it would literally take a constitutional amendment to get rid of those ones that are hanging out. But in the future, we would like to propose that maybe constitutional amendments have to pass within such time. Things like flag burning amendments, making burning a flag illegal. Because remember, even though currently under case law it is protected by the First Amendment, it is recognized as protected by the First Amendment to burn the American flag as protest, because it is required to burn the American flag if it is desecrated, being properly around right, or time to retire. But if you choose to illegalize something in the United States, like drinking, for example, which is illegal, then you can do so. All right, wholesale repealing. Amendment 21. Section 1, the 18th article of the amendment to the Constitution of the United States is hereby repealed. Yes, you can drink. 1933, we're in Depression, and people need a little something something. Section 1, the 18th article of the amendment to the Constitution is hereby repealed. Section 2, the transportation or importation into any state, territory, or possession of the United States for delivery, use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. Yes, we still have the authority to regulate alcohol. That's a little nod to the temperance movement. Section 3, this article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states as provided in the Constitution within 7 years of the date of submission hereof. Hey, there's that restriction again. 2 in a row. Yeah, that's because people needed to drink. Congress in February 20th, and this is the quickest one, by the way. I believe it's the quickest one. Yeah, 5th December, same year. People needed to drink. 22nd Amendment. Section 1, no person shall be elected to the office of. And that one actually has a cyber relevance. I feel like I should pause. Because it says it's still illegal if the state says it's illegal. It says that shipping intoxicating liquors, or whatever else that means, because to define liquor, we have a definition now that maybe it wasn't a definition then. Maybe it was. Don't know. But shipping it between states is illegal, or regulable, depending. Online alcohol sales. Feel free to use that one, because you're going to need 5. No person shall be elected to the office of president more than twice. Hey, look, 1947. Something happened. No person shall be elected to the office of president more than twice, and no person who has held the office of president or acted as president for more than 2 years of a term to which some other person was elected president shall be elected to office of the president more than once. But this article shall not apply to any person holding the office of president when this article was proposed by the Congress, and shall not permit any person who may be holding the office of president or acting as president during the term within which this article becomes operative from holding the office of president or acting as president during the remainder of such term. Why did this even become a thing? Because FDR. If he hadn't died in office, he could have been king if he wanted to. Seriously. He could have dismissed Congress, sent them home, and said, I got this. He was that popular. Could have happened. And that scared some people. They said, well, that's not really our system. That's not how we're built. And we're really glad that he was here, and he did his thing, and thank you, but let's stop that. So, how many years can a president serve? Online guys. Everybody, how many years can a president serve?
10.
Yep. Good. Why do people always say 8? You ask people, they say 8. President can serve 8 years. False. It's 10, and you're actually the first person to ever answer correctly immediately. Usually it's that gut reaction. People just hit 8. I know this one. 8. Well done.
It'd be unusual circumstances.
Huh?
It'd be unusual circumstances.
Yes. Yes. And it's actually probably 9 years and 364 days. Don't know that for sure. Never tried. No, it's 1%. All right, 23. Section 1. District. The district constituting the seat of governance of the United States shall appoint in such manner as the Congress may direct a number of electors of president and vice president equal to the whole number of senators and representatives in Congress, district, blah, blah, blah. Okay. Remember earlier when we discussed the Electoral College? I said it was amended?
Yep.
Here it is. And until they let us vote online, still not cyber relevant. 24, unless you really want me to discuss 23. Hearing no objection. 24. 1962, ratified in 64. The right of citizens of the United States to vote in any primary or other election for president or vice president, for electors, for president or vice president, or for senator or representative in Congress, shall not be denied or abridged by the United States or by state by reason of failure to pay any poll tax or other tax. Well, this was a dirty trick that was being used. A poll tax was a tax that you paid to vote. And it was not illegalized as a practice until 1967. What's the best way to regulate something out of happening?
Tax it.
Tax it! Machine guns, tax it! Cocaine, tax it! Seriously, there's legal cocaine. Have we covered this in this class? Yes, there's legal cocaine. Look it up, medical grade. It's used in heart transplants. TikTok. And it costs a fortune. Heart transplants are expensive, and it's not just the surgeon. Although I would like a very expensive surgeon if I need one. Please. All right. No poll taxes. They were using that as a way to exclude minorities from voting. Again, probably not relevant until there is online voting. Or maybe it is relevant. You'll tell me. Article 25. Section 1. In case of the removal of the president from office or of his death or resignation, the vice president shall become president. Wait, wasn't that already a thing? Yeah, well, it was implied, very strongly implied, but now it is explicitly stated. Section 2. Whenever there is a vacancy in the office of vice president, the president shall nominate a vice president who shall take office upon confirmation by the majority of both houses of Congress. That's new. That was not implied. Congress got to choose CHUSE previously. Section 3. Whenever the president transmits to the president pro tempore of the Senate and the House, the Speaker of the House of the Representatives, his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the vice president as acting president, not true president. For example, George Bush sent word to Congress, both houses, that he would be unable to discharge his duties as president for the term during which he was undergoing anesthesia for an annual exam. This is a real thing. Many presidents file such papers. During the time when the president is unable, because they're under anesthesia or a medical procedure, the vice president is sworn in as full acting president. When the president wakes up, regains his composure, he sends written notice to Congress again that he is ready to retake the office. The vice president steps down as acting president, and the president retakes his office. That's how it works. And it's right there. Section 4. Whenever the vice president and majority of either of the principal officers of the executive departments or of the such bodies of Congress may by law provide, transmit to the president pro tempore of the Senate, Speaker of the House for declaration. I just read that one, didn't I? Thereafter, when the president transmits to the president pro tempore of the Senate and the Speaker of the House, I'm speaking really fast, I apologize. He shall resume the powers and duties of his office. I already said that. Okay. He shall resume the powers and duties of his office. Sorry about that, I got lost. It's not paragraph. The vice president and the majority of either of the principal officers of the executive department or of such other body of Congress as may by law provide, transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives a written declaration that the President is unable to discharge the powers and duties of his office. Thereupon, Congress shall decide the issue assembling within 48 hours for that purpose, if not in session. Huh?
You say that. Then I can't.
Yes, they can say no. They have a time period where they can say, no, we don't think you can do the job. And they have to react quickly, move quickly, go back to session, and figure out what to do about it. This is really new. This is 1967. Very interesting.
What happened?
Well, what happened in 1962?
Yeah.
Yeah. And then they're like, wait, what if this had happened? What if that had happened? What if he comes back? Does he get the job back? What if he's brain dead? What if he's not brain dead? What if he wants it back but we don't trust him anymore? This is serious. It was all of that. And so they provided, oh, guess what? Guess what this one is lacking? Huh?
Oh, this is not like
This is not lacking a timestamp. This can be ratified at any time, and it didn't actually take all that long. How long do you think it would take something to get ratified these days? I'm not sure it's possible to get anything ratified.
it depends on the.
Amendment 16. Amendment 14, Section 2 of the Constitution was modified by this amendment. Section 1, the right of the citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. What was happening in the 70s? Because guess what? This one happened even faster. Huh?
March or July.
Yeah, March to July.
Oh.
That's the time for it. What was happening? 1971. Online people, what was happening? Yes. Vietnam. Vietnam. Say it anymore. It was happening right then. And who was going to war? If you can stand up, raise your hand, look over the counter, they take you for a while there. Seriously. Very few people got rejected for service during Vietnam because they needed people. In fact, many people were selected for service. Something called selective service. Also known as the draft. Many people were drafted, and those people, very much like taxation, no taxation without representation, very much like that, they said, wait. I can die for the country, but I can't vote for the country? And there was so much movement and so much pressure behind that it was ratified in just a few months.
So this is for the right to vote?
This is the right to vote at 18. It changes the voting age from 21 to 18. Congress shall have the power to enforce this. It seems like they do that for all the voting laws, because they're like, we don't know what dirty tricks politicians are going to come up with. And then there's what we started with. Proposed in 1789, ratified 1992.
Well, that one passed. You think we could pass more?
There's one more out there.
But I mean, everybody hates Congress.
That's
probably
true.
what.
Yeah, well, 1992 was also a contentious year. And in fact, I hate to break it to people, but we don't live in the most contentious times. We don't live in the most violent times. We do live in very polarized times, but we don't live in, it's not the worst time to be a cop. I hate to break it to all my cop friends. It's not the worst time to be a cop. If you look at the statistics of homicides of cops by population, 1929 was the worst year in the history of our country to be a police officer. 1963 is a close follow-up, and I have the statistics in my office to back myself up. I keep them there because I make this claim, and sometimes people get really angry with me and call me anti-cop, which I am anything but. But it is not. It's just a fact of the math that we live in one of the safest eras of our country's history. And we have trouble seeing it because we have it so good.
I also feel like the word spreads faster, more widely now. Like,
The
go to 29 and newspapers and stuff, and then now I open Facebook in the morning and I find out what happened 30 minutes ago.
Sure. And that's both good and not so good. And that's the whole point of this class, is we don't know how to handle that. We don't know what the implications of that are. And that's the world that we're going to inherit when we go out into the field.
Body cameras.
They are. They're putting body cameras on cops.
What's the keep?
Good or bad?
What's that to keep popping up on YouTube all the time?
Yeah, what keeps it from popping up on YouTube? That's definitely an issue. I mean, do you have a right not to have your arrest published on YouTube? Actually, no, you don't. You don't, especially if it was a legit bust. Now, wrongful arrest has always been a thing, and you can fight that. You can sue them for wrongful arrest. But wrongful posting of YouTube? That's a new thing. That's going to happen. That's this class. That's this field. Cyber law it is not a defined area of law yet. And maybe one of you will be one of the people who help define this area of law. Welcome back. Maybe one of us will be the ones to help define this area of law, to figure out where it fits and what's new and what's going to fit where, how we're going to regulate it. Because even regulation, when we start to consider issues of jurisdiction, of sovereignty, whose laws apply? The Supreme Court says that you can't, a foreign nation can't sue a U.S. national under foreign laws. But when are we going to start creating laws that allow them to sue them under our laws? 2 weeks ago, the British government petitioned the United States to be allowed to serve arrest and search warrants inside the United States.
For what?
Anything. Anything under British law. That's what they asked for. They're not going at it through the courts. They're going at it through the executive. And if the executive grants the power, it's going to be a while until it goes to the courts, because if they pick up people, if they pick up non-U.S. citizens, right? If they go after a British citizen inside the United States under British law, using British police, it's quite possible that it won't even make the news. They were apprehended, a British person was apprehended by British police for breaking British law. Okay. The average person is not going to see the headline. They're going to say, why is that a thing? Some cops arresting some dudes. What they're going to leave out is, in Los Angeles. And so how do we feel about that? Not just how do we feel, but how do we rationalize that? How do we reconcile that with existing U.S. law? Or is it time to propose new laws, which is what you're going to do at the end of the semester, if you will. So let's talk about this week's assignment. I left it up. It's right here. Here's what I want you guys to do. Oh, that's the wrong one. That was last week. I want you to contextualize your knowledge of the Bill of Rights. I'm assigning you the First Amendment. I want you to find an example or explain a justified implication of each of the 5 planks of the First Amendment. Then, I want you to select 5 more amendments. And I want you to do the same thing. I'm going to post this up right after class. Open it up. We'll be doing 2 weeks just like always. And I want you to do a review of 5 of the amendments of your choice. Do not pick one that is absolutely not cyber relevant. That's cheating. I have now said it. That's the loophole. I'm closing it. For example, the First Amendment, 5 elements, would be a case of an example of free speech on the internet. Regulation thereof, I might add. Cyber relevance. Okay.
I'm doing my case review about libraries being, it was a case a long time ago, but libraries having to use internet filters in order to get government funding. So do internet filters.
Right, and now they're not allowed to use internet filters. Yeah. Libraries that accept government funding are not allowed to use internet filters as a result of the case she's talking
United States issue.
Yes, it needs to be a United States issue because it needs to fall in the United States. Unless it was an online issue that was rejected under U.S. law based on one of the amendments. This cannot be from the normal body of the Constitution. This is not Articles 1 through 7. This has to be one of the amendments, one of the 27 amendments. Okay? Assign the first one with its 5 blanks. Find something relevant, and then pick 5 more. Make sense?
Is it 6 within one review, like one paper, or are we doing 6 separate reviews? Like
6
6
within one
documents? Okay, 6.
Yeah?
Yeah, that's why that was
Yep.
the case I was.
The internet page. Yep. And it got thrown out. Rejected. We're going to cover that stuff in 2 weeks, so that's great to focus on. That kind of thing, right? Cyberbullying will be another one, right? Does your right to free speech allow you to harass other people? Does your right to free speech extend to an unequal relationship harassment? And by unequal relationship, under the law, if I harass you mercilessly, if I try to extort sexual favors out of you for a grade, that's illegal. I'm using a position of power, an unequal relationship, to coerce activity. However, in cyberbullying, there's a different issue. For example, does a 30-something-year-old of normal, average, or above average intelligence have any trouble trolling, disturbing, or taking advantage of the mind, not necessarily the body, but the mind of a 13-year-old? Can you mess with the head of a 13-year-old as an adult person?
Yeah.
Absolutely. It is an unequal relationship. And that unequal relationship causes ground for problems, because if you are exercising your supposed free speech to bully somebody, and you happen to be, say, a mom of a cheerleader who has a problem with another girl at school, and you as the mom want to be a cool mom, and you decide to harass that other kid by pretending on MySpace to be a kid of her same age, using your 30-year-old intellect to pretend to be a 13-year-old and mock, ridicule, bully, and harass the other 13-year-old girl who already feels like an outcast, not that that matters to this situation, until she hangs herself, which happened. Feel free to look it up. You will go to jail because she did, for abusing your speech in an unequal relationship. However, if I just harass you, and we're equal, when you're no longer in my class and I feel like harassing you, well, under the law, that's not an unequal relationship. Until I try to exercise power by saying, well, I'll just change your grade. As long as I leave leverage, that kind of unequal relationship leverage, out of the harassment, no crime. When you talk about threats, has anybody heard the phrase terroristic threat?
Yeah.
It's thrown around a lot. I'm going to kill you, terroristic threat. I'll beat your face in, terroristic threat. I'll cut you, I'll hit you, I'll break you, whatever. Terroristic threat. But not necessarily, because in order to be a criminal threat, it is supposed to be credible. Has anybody ever said anything that they didn't mean? Yes. So to be a terroristic threat, it is supposed to, 1, terrorize the other individual, actual terror. It's been way overused. And it is also supposed to have a measure of credibility. And so, if a 6-year-old threatens to crush my face, I'm allowed to laugh, and the law does too. It's not credible.
So you can't sue that
I
6-year-old?
can't sue the 6-year-old. But if Hulk Hogan explicitly says the manner in which he would crush my face, and there's some proximity, like I'm an identifiable person with an address that he can find, that might be more credible. Sorry, Hulk.
He doesn't exist anymore.
Huh?
He doesn't exist anymore.
He doesn't? Like he's a has-been, or he died?
No, he is alive, but he said some
Oh, yeah.
So, yeah.
Yeah. No, that was stupid.
They were
Also, thank you, Internet.
Yep.
All right, so does the assignment make sense? I want you to contextualize your knowledge by finding examples, cyber-relevant examples of the application of your chosen amendments. I know for a fact there are applications of the First Amendment, all 5 steps. I want an example for each step. Unless the same example works for 2, in which case bonus. Make sure you justify it because your peers have to understand what you said. Again, remember, rubric grading peers. The length requirements, if you go over the length requirements, I'm going to remove the over. You cannot do this assignment in under 1,000 words. There's no way you can effectively do this assignment in under 1,000 words, but I am going to remove the top limit of 1,500 because you might go over depending on what amendment you pick. Try to be brief. Don't waste your colleagues' time. They're going to try not to waste yours. Don't waste theirs. Okay? All right. Online guys, any questions? Is it fairly clear? Okay. This assignment usually ends up being more fun than it starts out sounding. And so try to have fun with it. You can find wacky, weird, awesome examples. Okay? The Constitution applies in a myriad of unsuspecting ways.
When you say examples, like cases, or do you want?
Yeah, I want examples like from the news. Go find out news examples and/or cases that actually went to court. Okay?
So it doesn't actually have to end up in court.
Yes, you're choosing cases and/or news stories. It doesn't actually have to have gone to court. It can be, or it doesn't have to have gone to an appellate court, right? If you're saying they were tried as criminally for speech, for example, they can just have been convicted. Okay? All right. Yes, I want you're going to show your understanding of the cyber relevance. These are cyber cases. Show your understanding of the cyber relevance. So online bullying would be a free speech, right? So we have limits in in-person speech. Have we found an applicable limit to online speech? Okay. All right. Any questions before we go? Online people, questions? Blake already asked one. Anybody else? And you can use your microphones too. The speakers will work.
Nope, I'm good.
Okay. All right. Well, that's all I have tonight. And so, hearing no objections, I move to adjourn.
All in favor?
Aye. All right. Have a good night, guys. I'll get this assignment posted tomorrow, and I'll get the Dropbox up ASAP.